Well, good morning and welcome to the last regularly scheduled argument day of our fall 2019 term. Will the clerk please call the first case?
Yes, and the first case will be argued under Rule 20 of the Rules of Appellate Procedure, Raymond H. versus Cammie H., docket number 180875, and this is an appeal from the Circuit Court of Mercer County.
May it please the court, it is a privilege to be here. My name is Anthony R. Vanieri, and I represent the husband in this case. We bring to you basically two issues. The first issue is really not contested. In equitable distribution, a material asset, we call it the Lindell Avenue property, was omitted from the final calculation in equitable distribution. It's $105,000. It's a significant sum of money. It's unquestionably a marital asset. I do not believe that that is disputed by the wife in this case. But the issue that brings us for the Rule 20 argument is the application of West Virginia Code 43-1-2, which is the Notice of Conveyance statute. The family court in her June 15, 2017 order did a very nice job applying the statute as this court had directed in Stanley v. Stanley. She took the fair market value of the property conveyed in each deed of trust and included it into equitable distribution. On appeal to the Circuit Court of Mercer County, the Circuit Court said that we were not to do that. We were to value a security interest, which ultimately ended up being the amount of the notes. We submit to you that this is error because a plain reading of the statute does not call for that at all. Subsection A of the statute defines what a conveyance is, and it includes a security interest. While it triggers what is to be applied, it does not define the remedy in subsection D. In other words, subsection A says a deed of trust is a conveyance that is to be included into the calculation of marital property. Subsection D says the value of that property conveyed at the time of the conveyance is to be included into equitable distribution. The family court did that in her June 15, 2017 order. When the Circuit Court remanded it back, we then had to apply what was supposed to be the value of a security interest. The courts determined that it was the amount of the notes. I submit to you, using the amount of the notes does nothing more than standard equitable distribution would do, because we get the principal reduction anyway. To use the amount of the note as the basis for the value of the property not only doesn't give you improvements and other things that standard equitable distribution would give you, but for example, in the case before you, some of the debt that was included in one of the notes was for property that was not even described in the deed of trust. The statute, the legislature never contemplated including debt to be the basis to value property for purposes of that statute.
May I ask you, and I don't know if you'll know the answer, the history of this statute. This statute was passed in 1992.
Yes, Your Honor.
And the full load of equitable distribution statutes did not come in until 2001.
Yes, Your Honor.
And yet this statute references equitable distribution.
It does.
Was that in connection with another series of statutes, which I have not gone out independently researched yet? They used the term equitable distribution in the statute, but the equitable distribution general laws didn't come in until 9 years later.
Your Honor, you are correct. In 1992, courtesy and dower were abolished, and at the same time, the notice of conveyance statute was implemented. By that time, we had some statutory provisions on the books, and we had evolved into that from the LaRue decision from back in the 1980s. So I don't know that we called it technically equitable distribution, but this court in Stanley did a great job of bringing the statute through the process and saying, look, if the notice of the conveyance is not given, you didn't even have to have the conveyance within the time period to which dower would have actually applied. In other words, pre-92. If it's after 92, this court has said if dower would have applied.
And dower would have applied to what is now classified as separate property, correct?
Unquestionably, Your Honor.
Okay, because I found it curious that some of this property at issue was clearly separate property,
Yes, Your Honor.
and yet this statute, basically, due to your contention, lack of notification, basically became marital property.
That is correct,
And
Your
that
Honor.
wasn't changed by anything in 2002 statutes.
I'm not aware of it, Your
Okay.
Honor.
All
This
right,
court
thank
in
you.
Stanley, boy, y'all did it is a very detailed analysis that brings us through, and it's a strict construction of the statute. It's been declared by this court to be plain and unambiguous. It says the value of the property conveyed, and it includes any property that the person owns to which dower would have attached. And the reason is, Justice Workman, the reason is, while there's no remedy beyond the notice, if a person found out that his or her spouse had conveyed property, you would have the remedy to go to court and try to do something about it if you thought you were aggrieved. It's when we don't know about the conveyance where we lose rights.
Well, here, had there been notification, it would have been all right, wouldn't it, for the wife to transfer the property because it was her separate property under the 01 forward statute?
Absolutely. If there was notice, unquestionably, we would fail under West Virginia Code 43-1-2. But let me make a very important point here. The normal equitable distribution in this case would rise to the level of $208,000 anyway. The application of the statute in this case would give us $214,000. Normal equitable distribution would include the $115,000 increase in the value of the Green Valley property, the $76,000 pre-note principal reduction on the two properties, the post-note principal reduction on the properties of $78,000. It would also include the Lindale property. So what I'm suggesting to you is there was a concern at the end of Stanley that perhaps in some applications this statute is harsh. This court made a very clear statement. Number one, the statute says what it means and means what it says, and harshness doesn't really play out. However, in this case, and we didn't know it at the time we were presenting the case, but normal equitable distribution would give us 208 of the 214,000 anyway, so there's going to be no harsh result doing in this case what you did in Stanley. The difference in this case is we have a deed of trust. Of course, the deed of trust is a conveyance to a trustee. It triggers the statute in subsection A. The remedy in subsection D is the same for all conveyances. There is no distinction between a deed and a deed of trust.
So your other error is that you basically say that the value was computed erroneously.
That is correct, Your Honor, because the difference is by applying the value of the note and omitting Lindale, instead of my client getting either the $214,000 that he would be entitled to with the application of the statute or $208,000 with just normal equitable distribution, he falls to $39,000. The omission of Lindale is a $105,000 mistake, and it was inadvertent. I would say this to you. The family court judge did an outstanding, detailed job. The omission of Lindale was nothing more than a pneumatical omission, okay? You can see in her findings that she's talking about Lindale, but when she totals it up, it's easy to overlook Lindale because it too was on the deed of trust, but it's $105,000 above the $325,000 Green Valley property. It's clearly omitted. It's a material asset. They don't really dispute that, but this statute is what brings us to you today.
Any other questions? All right, well, let's hear from the other side.
Thank you.
Good morning. I'm Deborah Kilgore, counsel for the respondent, Cammie H. The circuit court did not err in its interpretation of the statute 43-1-2. The language that is at issue in this statute is, quote, the value of the real estate conveyed. And the statute further provides that a conveyance includes the creation of a security interest. In this case, the instruments of conveyance are deeds of trust that create security interests. So the issue is the value conveyed by a deed of trust. The cases that respondent cited in her brief, this court has long held that while a deed of trust passes title to a trustee in trust, it does not operate to change title, to change possession. The trust creditor acquires no estate in the property, no right to possession. The creditor only has a chose in action, that is, a right to sell the property in the event of default. The cases that we have cited further demonstrate that the grantor remains in possession of the property. The grantor still owns the equity. The grantor still owns the minerals, the timber, the rents, and the profits. It's only in the event of default that the property becomes subject to sale, and then only to the extent of the debt secured. That is, only the balance that is owing at the time of foreclosure can be satisfied from the sale proceeds. So we submit the circuit court correctly held that the value of the real estate conveyed by a deed of trust is not the full market value of the property, it is the value of the security interest, the value of the interest secured by the property or by the real estate. Then, on remand, the family court found that value to be the original principal amount of the notes secured.
In Stanley v. Stanley, did that involve what would be classified as separate property under the equitable distribution statutes?
I believe Stanley v. Stanley did. I think wife owned that property, although it was the residence that the parties had lived in throughout the marriage. And I think husband had contributed some money to that, but it was separate property.
But you don't make any argument here about the applicability of the statute. I guess Stanley v. Stanley, that's why I asked, clearly interpreted as is being interpreted, but did anything in the equitable distribution statutes which created the concept of separate property or premarital separate property, you don't argue that any of that changed the rule of this statute?
No. I don't
I
think
thought
so.
you would.
I don't think it.
I don't want to create conflicts where none exist.
You know, and Your Honor, I did not research that issue at all. I think it's a good point to research about, you know, when the statutes came into effect. I know in looking at both of the statutes together, really they don't make sense when you're reading them together, although in a sense they do, because you end up with the same result when you are valuing the marital interest in separate property. The increase in value of separate property, you end up with the same result. But Stanley did not involve a deed of trust. It was a deed. Wife conveyed the property away during the divorce proceedings to her children and reserved a life estate for herself.
But would it have been separate property under the definition of that statute?
I think so, yeah. It was titled in her name alone, but there may have been some marital interest in that separate property. Yeah. But anyway, that the value conveyed by a deed of trust can be no more than the debt secured, I think is further illustrated in the case of a second or a junior deed of trust. Because that second or junior deed of trust cannot convey, again, the entire full market value of the property, it conveys only a security interest in the equity and only up to the amount secured. In other words, in this case, Your Honor,
I'm not sure what that feedback is. Claire?
okay. But in any case, Your Honors, what if in this case...
Sorry about that.
What if in this case...
The lawyers that, you know, I don't like, I always tell them that's like the lie detector that...
I swear I'm not lying. Anyway, I have a good example.
Yeah, I'm sorry.
No, that's okay. In this case, what if in this case the respondent wife had conveyed second deeds of trust within 5 years of divorce? And we apply this statute, 43-1-2. Surely, the entire market value of the property would not be brought back into the marital estate twice, once with the first deed of trust and again with the second deed of trust. That, I think, would be an absurd result to value the property at its full market value twice. In fact, unlike transferring the property away by a deed, which would probably be better because she would have no more interest, she would still own the property. But then we're saying that we're going to value it twice at its full market value. There are other arguments that the petitioner has made in his brief for why this should be valued at the full market value. As for why it should be valued, the amount of the debt secured is because that's all the property can be subject to at the point of sale. The petitioner also argues that in his brief that because the instruments in this case, the deeds of trust in this case, secure future advances or future money that may be borrowed, that the full market value must have been conveyed by a deed of trust. But that doesn't change the fact that in the event of default, only the amount then owing at that time can be satisfied from the sales proceeds. In this case, the statute says to value the real estate conveyed at the time of conveyance. In this case, at the time the deeds of trust were created, at the time of conveyance, there's no evidence that there was any more owing than the original principal amount of the notes secured. So to determine value is not speculative. The other issue that the petitioner has raised in argument today is the claim that the Lindale property was omitted from equitable distribution. This is not quite accurate. This property, which is marital property, the Lindale property, was not really omitted. The family court just did not separately account for it as a separate item. Instead, the family court valued both the Lindale property, which is marital property, and the Green Valley property, which is respondent's separate property, jointly at $250,000, which, as we set out in the brief, actually results in overvaluing the Lindale property to the petitioner's benefit. So if there is any error, it is a harmless error to petitioner. If I may, unless the court has other questions, I would like to turn to respondent's cross assignment.
Seems like a good time to do it. I think we've got the mics calmed down.
Okay. The respondent submits that, Your Honor, this statute shouldn't even apply in the first place. She submits that the lower courts erred in finding that she did not give notice and that the petitioner did not have notice in the first place of the refinancing of her separate property during the marriage and of the deeds of trust. The statute provides two methods to prove notice. One is that the non-titled spouse actually signs the conveying instrument. The other is such other forms of competent admissible evidence. There's no dispute in this case that the petitioner did not sign the deeds of trust. But the evidence in this case demonstrates that the respondent gave notice and the petitioner had notice. The case of Stanley v. Stanley makes clear that the statute only requires notice. It does not require consent. It does not require the conveying spouse to discuss with or consult with her spouse or to involve him in the transaction. All that is required is notice, that the spouse be made aware. This case, it's true, the petitioner wife did not discuss the details of the refinancing with her husband. She did not involve him in the transactions. She did not involve him in her businesses. But the petitioner husband worked in the past 8 years as a bank loan officer. And the respondent testified that she told the petitioner prior to refinancing the debt against her separate property during the marriage that she was moving her loans to another bank. She told him that she was borrowing against the loan on the Shenandoah Estates property, which is the residence where the petitioner also lived. She told him she was borrowing against this property to build a pool. She also told him she was borrowing against her business loans to consolidate that debt and to improve her business property. Yet in this case, the petitioner claimed for the first time at the final divorce hearing that he first learned of these deeds of trust 2 to 3 years after they were created, after the petition for divorce was filed, and after the first temporary hearing in this case, when he says he went to the record room with his attorney. But there is evidence in this case that directly contradicts this claim, which was not addressed by the lower courts, and that is a text message. As I said, the petitioner testified several times. He first learned of the refinancing and the deeds of trust after the first hearing in this case. But on the day before that hearing, he sent a text message to his wife telling her in this text message that he has an interest in her business and in her home because, as he said, she rolled them into loans after marriage. He then admitted in cross-examination that he knew before this hearing, when he had testified that he did, that the property had been rolled into loans. So clearly, he knew about the deeds of trust and the refinancing before the first hearing, before he says he went to the record room. So we submit that this fact, as well as others that we have outlined in the brief, and the fact that he had worked for 8 years as a bank loan officer demonstrates he had knowledge of the refinancing. He was aware. So the lower courts were erroneous in this finding, and if this court would reverse on this point, then the statute doesn't even apply in the first place. Finally, I would like to just point out a few things. And that is, there is no evidence in this case that the wife, the respondent, hid anything from the respondent, from the petitioner. There's no evidence that she created the security interest in her separate property to somehow dissipate value. There's no evidence that she tried to gain an advantage somehow in the divorce proceedings by creating this debt. And in fact, the petitioner benefited from the debt. He swam in the pool that was built from the debt secured by the Shenandoah Estates property, and he enjoyed the income that the respondent earned from the improvements she made to her business property. Thank you.
Any other questions? All right, thank you.
Thank you.
Brief rebuttal, maybe you could begin with the cross-assignment of error.
Be glad to, Your Honor. First of all, you know that the family court in 16 pages of findings didn't lose sight of the fact that the wife could not even state that she had given notice of the deeds of trust. She couldn't even say it. Her argument was, by telling her husband she was going to borrow against the loans, that in fact that meant there would be a new deed of trust. But I would remind the court, in many cases, deeds of trust are assigned. There are no new deeds of trust, and this particular wife had testified both before the family court and in deposition that she could borrow money without a deed of trust. In fact, if you'll see the quoted testimony in the brief, Ms. Kilgore actually corrects me on a question where I'm asking about a loan and a deed of trust. She says she didn't necessarily say there was a deed of trust. So the family court in 16 pages of quoted testimony did not even remotely get this wrong. This text message occurred the night before a temporary hearing, 3 or 4 years after these deeds of trust had been executed. The text message deals with personal property, vehicles. I have an interest in your business. I have an interest in the properties. It has nothing in it that talks about a deed of trust. The husband said after the temporary hearing the next day, he and I went to the record room, and we discovered these deeds of trust. Now, she says this to you. She says, well, I told him it was rolled into the loans. She says she borrowed against loans. She never said that she actually signed new deeds of trust, ever. She also says she didn't intend to hide anything from the husband. And I ask you this, in the record is at least one deed of trust that she signed after the parties were married, where she signed as a single person. There's another deed of trust that she signed without the husband's signature. There was no notice given on that, but it was more than 5 years old. She also testified that within 7 months of the final hearing, she had taken a $65,000 loan. She couldn't even tell us if there had been a deed of trust. She couldn't even remember the loans until the family court prodded her. So I say to you, assets were hidden. She wouldn't title the Lindell property in her husband's name because she testified she didn't want him to have control over that. She wanted to keep it in her name so that nothing would happen to it. The family court didn't get that wrong. And I would like to go back to the primary argument here. The wife has misconstrued the purpose of a deed of trust with what it actually does. In Arnold, this court said two very important things. Number one, the trust creditor does not receive title to the property, and that's true. The banks don't receive the title to the property. The property, as Syllabus Point 7 in Arnold says, is conveyed to a trustee. The fully described property in each deed of trust goes to a trustee, not to the bank. Our point before you today, our argument is consistent with what you did in Stanley. Justice Workman, you were asking about in Stanley, was there separate property involved? She is correct on that. But the emphasis was, would dower attach to this real estate? And yes, it would. When people inherited property before the statute was abolished and passed, their spouse had a dower interest on inherited property. We know this. So,
But I was curious on why when the equitable distribution statutes were enacted and created premarital separate property, why this statute wasn't amended in any way. It's interesting.
It is, Your Honor, and frankly, the notice of conveyance statute come on board at the same time. I don't know the wisdom of the legislature. What I do know is the wisdom of this court in Stanley v. Stanley, and you all made it explicitly clear. I think this dower issue was in fact addressed in that case, so I think you have the authority there. I want to remind the court about one other point here. We're talking about, well, what if there's a second or third deed of trust? The statute is triggered under subsection A to then go to the remedy, and the remedy is the value of the property conveyed, whether by first, second, third deed of trust. The debt does not measure the value of the property. There's nothing in the statute that says debt defines what the value of the property is. And you know that's particularly true in this case because part of the debt that stood for, or that these deeds of trust secured, was debt for property that was not even included in the description in the deed of trust. There's debt satisfied by the notes, and the property that it satisfied is not even in the deeds of trust. How could it ever be possible that the legislature intended debt to define the value of the property conveyed?
What about Ms. Kilgore's argument that that doesn't make sense, especially if you look at a second or junior deed of trust? If you take it and value the property at market value the first time, and then there's in the period of time required, there's a junior deed of trust or a second deed of trust issue. You go back and value that at the market value and add that into the value of marital property. I mean, how do you get around that issue?
Simply because the debt doesn't define the value of the property. What if, for example,
well, that's my point. If she encumbers non-marital property twice, are you going to add it in twice?
the statute says even if the consideration is already included in the valuation for equitable distribution, it's to be included anyway. The statute in part, Your Honor...
So that's your harshness argument.
Well, it is harsh. This court has addressed the harshness issue. But what I wanted you to know is in this case, if you said, all right, let's throw out the statute and just sent me back for the calculation of equitable distribution, let me have the findings that were omitted by the family court and circuit court in round 2 of the case, Your Honor, I still get $208,000 just on principal reduction and increase in value. There won't be a harshness impact in this case if you would do that. The difference is $6,000. I have the luxury of arguing to you today that while the harshness was a real issue in Stanley, it is not today.
Thanks.
All right, I think we understand. Thanks to you both. This case will be submitted.
The second case for oral argument is also under Rule 20 of the Rules of Appellate Procedure, MH versus CH and BH, docket number 180972, an appeal from the Circuit Court of Kanawha County.
Good morning, Your Honors. My name is Clint Smith. I represent the mother petitioner in this action. The situation is that in August or September of 2016, my client started a job that required that she be at work at 7 o'clock. Her child had to be could not get on a bus until 6:55. In order to deal with all of that, there was an agreement reached with the respondents in this action that what would happen is the respondent would babysit the child. Then when my client got off work, she would pick the child up, take him home, feed him, do his homework, give him a bath, do all of that sort of thing, and then in the next morning, bring the child back to grandma to put him on the bus. Well, they did that for a period of time, a month or so, and then decided that what would happen then would be my client would pick the child up from the respondents, do all of the evening things that she had done before, except that when the child was bathed and ready to go to bed, take the child to the respondent and put him in bed. And then grandma would wake him up in the morning and put him on the bus. They do this for until December. Then the respondent comes to my client and says that there has been a CPS worker in contact with her and there's an investigation. My client never heard of it, never was contacted by CPS, never was involved in any kind of CPS investigation. Then the respondent then claimed the CPS worker told her that unless my client signed a transfer of custody of the child to the respondent, CPS was going to take the child and put him in foster care. Under the pressure of the choice between leaving the child with a trusted, loved family member or having the child put in foster care, my client did the right thing and signed the transfer and allowed the child to go stay with grandmother.
And you contend that, in fact, that was a false representation made about the CPS?
Yes, there is no evidence whatsoever that that conversation ever happened. The CPS worker was not called. There was no evidence offered whatsoever about the alleged CPS investigation.
Well, they had been called, hadn't they? But there was no open investigation. Am I right about that? Or
the respondent testified she called
Right.
CPS in November of 16. This conversation took place in December, but it was also represented to my client later that whatever investigation that was closed without, like I said, without even contacting her.
well, let me ask you one question. I don't mean to shortcut you because we're pretty familiar with the factual basis here of the arguments, but according to my notes, that signed temporary custody agreement was not put in the record nor examined by the court below?
I
Is that
believe
correct?
it is in the record, Judge.
You think it is in the record?
Yes.
Okay.
I think it,
I'm
I
going to find it.
was looking last night, and I believe it's in the appendix.
Isn't that a one-sentence transfer?
Yes.
And then it says, I temporarily transfer custody to so-and-so until further notice?
Yes, that's the document that we're
Okay.
talking about. Yeah.
Yeah, that's the one that
Well, if the court is familiar with the facts, then I will go on to the legal part of it. The problem here is that the court below applied the standard of Overfield to the situation where a party has signed a document transferring custody of a child, and then also applied the FIG, the guardianship statute, and found that the child should stay with the respondent. There are two problems with that. Under Troxel, and the conflict it has with Overfield, Troxel says that a fit parent is presumed to be fit and has to be proven to be unfit before the state can become involved and interfere with the decisions of a fit parent.
And in that same connection, when the petition for guardianship was filed, I take it there were either allegations or some sort of evidence against the mother by the grandmother of neglect?
No.
Because it seems to me that Rule 13 of guardianship rules requires that this kind of thing go to the circuit court whenever any type of abuse or allegation of abandonment or any of that, and this went to the family court.
It did, correct. What happened, Judge, back to the facts, when my client finally put her foot down and said, I want my child, the respondent said, okay, I'll pack your stuff up, you can come get him this evening when you get off work. And instead of doing that, they went down and filed a domestic violence petition alleging that my client's boyfriend committed acts of domestic violence against the child. At a later time,
So there we have the abuse has reared its head there then,
well,
an allegation of abuse.
by someone else, not my client.
Well, but by someone in this case, the respondent.
Yes. The respondent alleged there was domestic violence. There was a final hearing on that in July of 17, and the domestic violence order was denied based on these allegations. The family judge found that these allegations didn't even arise, and their evidence didn't arise to a preponderance of the evidence, and dismissed the domestic violence petition.
Counsel, correct me if I'm wrong, but it appeared that the circuit court found basically, and the circuit court seemed to have some concern over applying Overfield, but basically said, as I read it, that the fact that she basically turned over custody here in this case, that she was no longer entitled to the presumption of fitness that comes from Troxel. And so how do you respond to that there was basically you have this presumption in Troxel, but in this case, because she voluntarily turned over custody, that she basically waived that presumption, and so then Overfield and statute applies?
The issue, though, is that she made a decision that a fit parent would make. Confronted with foster care or grandma, I'm going to have my child with grandma.
Which you contend was even a misrepresentation.
Yes. So she did something that a fit, proper parent would do. And then under Overfield, the problem is that in order to undo the decision that a fit and proper parent made, then that parent has to come back in and prove they're not unfit. It's a completely burden-shifting situation.
Troxel.
Excuse me, Judge.
Overfield flips Troxel.
Exactly. Well, actually, it's the other way around, because Overfield came first.
Well, but Troxel is we've not dealt with whether or not Troxel overrules Overfield. So
That's correct.
effectively, the statements that are in Overfield would essentially flip the presumptions that Troxel states. It doesn't matter whichever way you look at it. Essentially, Troxel says you're presumed to be a fit parent, and a fit parent has the right to make decisions. But then in Overfield, it says if you've given it away, you got to prove yourself to be fit to get your child back. Yes.
By virtue of doing something that is in the best interest of your child, you become presumed unfit, which is, aside from the unconstitutionality of it, makes no sense and is bad policy. The other part, and as a matter of fact, that is exactly a big part of the issue that Troxel had with the Washington State statute that was involved there. That was a grandparent visitation situation. And they point out in that well, first off, it says that there is a presumption of fit parents act in the best interest of their children. The decisional framework employed by the Superior Court directly contravened the traditional presumption that a fit parent will act in the best interest of their child. It's just completely, that's what they said dealing with the Washington statute, and that's the situation we have here.
But if you really look at syllabus point 6 of Overfield, it says that in the unlikelihood that the scrivener of a document voluntarily transferring the custody of a child between a parent and third person fails to express any intention as to the duration of the custodial change, then the burden is on, and I'm paraphrasing now, it's on the third party to prove that it was not temporary. So it seems to me that that precept of Overfield would have voted in your favor had it been applied properly.
Yes, it would. But the family judge got to, you sign the document, you have to prove you're unfit, or prove you're not unfit, and quit.
And according to this oldest point, they've got to prove, the third party has to prove by clear and convincing evidence that the transfer was not intended to be permanent. In other words, the respondent here would have to have proved that, not you.
That's true, and that never became an issue, but I do believe that the respondent's going to have a real problem with that because the verbiage of the document, as pointed out by the justice, although very short, it does clearly state it's until further notice.
How long has this been going on?
The original arrangement was August or September of 16. The DVP was filed in June of 17. The FIG was resolved October of 17.
Has the mother been able to see the child regularly during this whole long period?
Yes, as will be permitted by the respondents.
Okay.
And that's another problem with this, Justice. My client is still with the boyfriend, and they have a child, another child. They have a child. The boyfriend is not the father of this child. And when my client is seeing the child, the respondent knows that the alleged abuser of the child is with her, and they permit it.
I want to get back to Rule 13. Doesn't the Rule 13 of FIG's Family Court Infant Guardianship, I think that's what it stands for, as soon as there are allegations of abuse and neglect, that the family court is required to transfer that to circuit court? Were there not allegations of abuse and neglect in the guardianship petition? Did not the grandmother actually allege that there was abuse and neglect in the house?
She alleged that the boyfriend, yes, well, I guess yes, the boyfriend, they lived together.
She essentially said the boyfriend's beating the kid.
Essentially, yes.
Yeah. And so at that point in time, was not the family court required to transfer that to the circuit court?
Yes.
All right.
Just ask, even if you, under Troxel, and I understand what you're saying, that it was, you believe it's an improper shifting of the burden, but even if you assume that that was improper and that she was in fact a fit parent, how do you respond to the second part of Overfield that says you still have to show by clear and convincing evidence that the transfer back to her would have a significant benefit to the child? Or are you saying you don't have to show that because of Troxel? I just don't know what.
One, I would say you don't have to show that because of Troxel, because it is presumed. Secondly, we never got there. We never got that far. It was just you didn't prove that you were not unfit, and therefore that's the end of the discussion. So we didn't make it to that second step. The other part of this too is that the statute for the FIG statute itself is unconstitutional because it does not look at the fitness of the parent. If you look at what you have to show that it would benefit the child, and then you have to show these 5 or 6 different, and these 5 or 6 other different things happen. Nowhere in the other 5 or 6 things that you have to prove, or you can prove, is that the parent is unfit. You can.
Who has the burden to prove that? Those 5 or 6 things you're talking about. Where's the burden?
The petitioner.
The petitioner. So that would be, in this
case, it would be the respondent.
It would be the respondent should have to prove those 5 or 6 things.
Correct.
Right.
And if you look at the petition for guardianship, very, very clearly, there are allegations of abuse. Consequently, I don't know how this stayed in family court.
the family court erred.
But you didn't make that an assignment
I did
there,
not.
so.
But the thing about the FIG statute, though, is you have all these things that have to be proven by the petitioner. They have that burden, but nowhere in that statute are they required to prove that the parent is unfit. So if you come in and say, I can take better care of this child, and you can show one or more of these other things, even if you can't prove the parent is unfit, you get the kid, which is also a violation of Troxel. I mean, the situation, my suggestion to the court would be that the proper way of it is the parent is presumed to be fit. And anybody who is alleging the transfer, that was a proper, and if there's a transfer, that was a proper decision. When the parent says, okay, I want the child back, that is also presumed to be a proper and fit decision. And then at that point, the transferee, in this case the respondent, have the burden of proving by clear and convincing evidence that the parent is unfit. That's how you do all this under Troxel. Before there can be a divestment of custodial rights by a parent, there has to be proof that the parent is unfit. Somebody at some point has to say this parent is unfit. And we have a myriad of case law that establishes what constitutes being unfit. Part of the issue here with and this, I don't know, this may have played into a judge, or justice, I'm not going to speculate on it. You know, the issue too, though, is the family court found that the allegations of abuse, which were the same as in the DV, they weren't even proven by a preponderance, and dismissed the domestic violence petition. So there's a real issue there with how do you get evidence that didn't even rise to the level of a preponderance, get you to clear and convincing evidence, or even any other higher standard, that it proves that the parent is unfit.
You didn't argue res judicata, though, did you? I mean, that's what you're arguing. You're arguing that a prior court made a determination that the exact allegations that were contained in the guardianship petition were in fact not proven by a preponderance of the evidence. Aren't you arguing res judicata?
I raised that issue in the circuit court. I would like to think I said something like that in the family court, but I cannot represent to you that I remember saying something. But I did point out to the circuit court that you have an evidentiary problem where you have this evidence that doesn't meet the standard, a lower standard, now being used and applied where you need a higher standard.
Right.
Well, and looking at the family court's order, the family court found this was a temporary transfer of custody, and therefore it would have been, even if it had been in the proper forum, then it would have been the burden of proof of the grandmother to prove by clear and convincing evidence that the intention was for it to be a permanent. And that wasn't even addressed. That's part of Overfield, too. I think that there was a quick look at Overfield, but not a true analysis here.
Yes.
All right, well, let's hear from the other side. I'll give you an opportunity for rebuttal at the end.
May it please the court, my name is Tim Carrico, and I represent the maternal great-grandparents, the appellees here, and the petitioners below who are awarded guardianship of the minor child. Now, first, I respectfully submit that the application of the Troxel decision is being misconstrued a little bit here. As to Troxel, Troxel simply states and recognizes that parents have a fundamental right in making decisions concerning their children. But in the Troxel case, and this is as from Justice Souter, right from the opinion, its ruling rested discussing what the plurality decision was. Its ruling rested on two independently sufficient grounds. The failure of the statute to require harm to the child to justify a disputed visitation order, and the statute's authorization of any person at any time to petition and receive visitation rights subject to free-ranging best interests of the child standard. Now, the Troxel decision simply related to its grandparent visitation. It was a state court coming in and supplanting its decision-making on a fit parent's decision on what a grandparent should have. That's all that related to. This case doesn't relate to that. It has two key components to it. Number one, we have the temporary transfer.
Wait. You said Troxel doesn't apply in this case?
To the extent it applies to the extent that it recognizes, and this court recognizes, that a parent has a fundamental right in parenting their child and making decisions concerning that child. But in that case, they weren't dealing with any allegations of a parent being unfit. The court didn't deal with that. This was simply grandparents coming in attempting to get more visitation that parent wanted to give. State court allowed it under that statute. And actually, the Supreme Court said the state court could have fixed it. The Supreme Court in that state could have fixed it by narrowly interpreting the statute, which they didn't do. But in this case, we're dealing with, number one, a transfer of custody, a temporary transfer of custody, and number two, specific allegations of unfitness.
Well, then how do you get around Rule 13 that this should have been heard by the circuit court, not a family court?
The review Rule 13 again, Justice Workman, yes, it clearly states that if there's allegations of abuse, it shall be reported. In this case, procedurally what had happened is my clients, the maternal great-grandparents, filed a petition for domestic violence protective order. That was set for hearing on July the 5th of 2017. That's the same day they filed for guardianship. And the domestic violence order that was entered dismissing the case, it does check where the judge puts their initials by the domestic violence protective order is denied because the petitioner failed to prove allegations of domestic violence of abuse by preponderance of the evidence as defined by West Virginia Code 4827-2002. That's July 5th, 2017. But then it goes on to state, an order will be entered in Fig 183, therefore the protection order will be dismissed. That's all it said. Now, the court does not have the transcript of the hearing that happened on that date. The court doesn't have the transcript of the hearing that happened in September, which was the final guardianship proceeding. But most importantly, procedurally, the maternal grandparents, the great-grandparents, filed a petition, a detailed petition alleging pro se, alleging specific acts that would be neglect by the mother by allowing the child to be around her boyfriend, who she's still with. But allegations of the child knows is aware where the parents get their marijuana. Allegations of physical abuse, and the court's aware of what was alleged in there. And actually, Judge Van Meter's finding on that. She disagrees. I believe they characterize it in terms of the child making noise, the boyfriend gets upset, and then spanks him hard enough to cause him to use the bathroom in his pants.
And was there evidence of all this presented before the family court?
Well, there was a hearing on July the 5th. Mr. Smith and I weren't present there. All parties were pro se at that time. We were at the last hearing, which would have happened in September, where we had a full evidentiary hearing at that point in time when there's exhibits. But yes, it's my understanding that evidence was presented on all this, and Van Meter, I believe, also heard evidence of it on July the 5th.
The exact same allegations for the domestic violence protective order were the same allegations in the petition for permanent legal guardianship. Is that correct?
Yes, sir.
And so why would not the finding of the family court in the domestic violence protective proceeding have operated as res judicata with regard to the guardianship proceeding?
Not being present at the hearing.
I understand. I've given you credit for not being there.
Well, did you not get a tape of it and watch it?
Well, Your Honor, as to when the appeal was filed, the Judge Van Meter made specific findings after we had the final hearing. I know that the petition that's been filed here is challenging legally the standard being applied, asking the court to overturn Overfield.
Well, if in fact, at the proceeding for permanent legal guardianship, I think it's number 6 of Overfield, essentially says, as I recall, that at that proceeding the burden would have been on your client to prove unfitness. Is that correct?
Well, Your Honor, I believe I'm reading the syllabus point differently. I believe 6 terms, the way I was reading it is that if there's an issue, whether it's a permanent or temporary, it's going to be deemed to be a temporary transfer. And that's what happened in this case.
Maybe I've got my syllabus points mixed up, but essentially Overfield would put at that proceeding, wherever it is in Overfield, is it your position that your client had the burden of proving that she was unfit, or did she have the burden of proving that she was not unfit? Well, I hate to wait. That's a double negative, right?
Based on the decision in Overfield, it's our position, or my position, my client's position, that the burden would have been on the mother to prove
that she was fit.
And that's based on the analysis from this court in the Overfield decision. And in that case specifically, this court recognized there were 2 competing interests that the court had to deal with. Number one, the parent's fundamental right, but also the equitable rights concerning the child to be free from harm. And that's what's centered. It's my understanding from reading that decision, which resulted in that decision with the burden switching.
So we've got 2 issues actually 3 issues in this case. Burden shifting, which you've just mentioned, but we've also got the issue of Troxel, and then we've got the 3rd issue, which just left my head. I'm sorry.
Abuse and neglect in family court.
Yeah, Rule 13. Thank you. Well, I'm glad you guys can read mine. But I mean, essentially, Rule 13, whether or not this case should have gone immediately, once the allegations of abuse and neglect, or allegations that lead one to believe abuse and neglect was occurring, use of drugs, family discord, the fact that she gave her child away, all that sort of thing, and that the boyfriend was beating the child. All those issues under Rule 13 should have immediately been transferred to the circuit court. So we've got 3 real big issues here in this case. Is that a fair statement?
Yes, sir.
Thanks.
Well, and let me ask you one question. In the evidentiary proceedings, which I guess you didn't watch them, so you have to speculate, but did she deny, or do you know, that she made a misrepresentation to the mother in order to obtain that temporary custody agreement?
Well, she denies that she made a misrepresentation to the mother. And my understanding, and even from confirming from their brief, the mother obviously confirmed that she called CPS and spoke with CPS, and they said the matter was closed. So there clearly was, based on her
report, but
there was a report, and they had a matter that had been closed.
But the allegation was that she had told her, if you don't let me have temporary custody, this child's going to have to go into foster care. And I guess, if you didn't watch it, I guess you don't know.
No. Your Honor, I was present at
Oh, you were present at that?
At the final hearing. I wasn't present at the very first proceeding that was on July the 5th, which was the same date the guardianship petition was filed and the same day the domestic violence.
So what was the evidence on that there?
Well, my understanding, from memory, Your Honor, that my client had been contacted. Her testimony was that my client had been contacted by CPS. And the reason why CPS got involved was the child apparently went to school. This was in December of 2016, and reported incidents that caused the school officials to call CPS.
But did she deny that she stated to her that there was an ongoing investigation and the child would have to go into foster care if she didn't give her the custody agreement?
In summary, she does not deny that was said.
Okay.
No. And she admits that, yes, she spoke to her and told her and led her to believe that if she didn't do this, CPS would get involved and take the child. Now, Judge Van Meter below considered this and discussed that in her findings, and what she found was, based on the testimony of the mother knew in about at least February of 2017 that the investigation was closed and hadn't done anything else. So there's other findings, not only of her allowing the child to be around the boyfriend, but also allegations that the mother wouldn't do anything. The parenting time was awarded to the mother, but just could not be around, the boyfriend couldn't be around the mother.
Was there evidence presented of all these allegations of abuse and neglect? Or did it strictly get dealt with under an Overfield v. Collins transfer of custody?
Well, the record was clear that the mother would see the mother, but would not spend any significant time with the child.
Now I'm talking about the allegations of abuse and neglect in the guardianship petition, whipping the child and stuff like that was alleged.
Most of it is hearsay. Other than the mother
was there
admits
evidence?
it happened, the mother admits that the spanking happened that resulted in the child using the bathroom in his pants. But mother contends it was a coincidence. Mother contends that the child just happened to have to go to the bathroom at that point in time, and that's why he used the bathroom in his pants. And based on, I don't believe.
Is that the only thing, or were all those other? There was numerous allegations of abuse in that handwritten guardianship petition.
Most of it would have been, it would be testimony about what the maternal grandmother, great-grandmother testified to. A lot of it was told to her by what she said by the mother. And the mother denied that.
And so I just want to make sure I'm clear, because we're kind of going back and forth around this a little bit. But under Overfield, it basically says when you have a natural parent transfers custody and they want custody back, that burden does shift to the parent to show that they're a fit parent, and then also that they can transfer, basically they can transfer the child and it's in the best interest, or it's a significant benefit to the child to transfer the child back to them. And I thought I understood you saying that Troxel in this case, that did not come into play basically in this case. And I'm still trying to understand, if you have a parent who has basically a presumption of fitness, that there has been no specific finding that they've been unfit because, there was the CPS complaint was dismissed, and can't point to a finding other than an allegation that there's unfitness. There's certainly allegation, but not a finding. So why does Troxel not apply in that case? Just if you can tell me succinctly, why you think Troxel doesn't override Overfield in that case?
Because the court did make specific findings based on, after we had the hearing in September, the court made specific findings of unfitness by the mother in the order, where she specifically states in the case at bar, at paragraph 23, the mother respondent has not proven by clear and convincing evidence that she is a fit proper. But then the court goes on. Based upon the evidence in this case, the mother has not taken any interest or responsibility for the child's educational, medical, or overall well-being for the last year, has allowed her boyfriend to whip this child until he has used the bathroom on himself, continues to reside with the boyfriend even though he may have abused the child, does not have a bedroom for the child, and has only seen the child 5 times since June 26, 2017, and for each of those times for 1 hour or less. So there are specific findings of unfitness. So the court went that far to make those specific findings. Now, I know they're after where the court applied Overfield, but we're not in a situation. We have a pleading that's filed. Mother's put on notice that it's alleged that she's unfit. We have an evidentiary hearing. The court makes specific findings. She has counsel. Petitioners are represented by counsel. and the court makes findings, specific findings of unfitness, that's why Troxel doesn't apply. It applies to the extent that the court recognizes, and this court has recognized, that a parent has a fundamental right to parent their child, but we have two things. The transfer issue, which is a big deal, and number two, the allegations of unfitness, which the family court found and believed based on its order. And going to the last point, I believe Mr. Smith was contending was under 4410.3, contending that the statute doesn't provide, or the court didn't make these specific, there's no requirement of per se unfitness. Well, the statute specifically reads that a court may appoint a guardian for a minor if the court finds by clear and convincing evidence the employment is in the minor's best interest and the parent's consent, which is not the case. The parent's rights have been previously terminated, not the case. The parents are unwilling or unable to exercise their parental rights. That's number 3, and I'm contending that 3 would be in play. Number 4, the parents have abandoned their rights by material failure to exercise them for a period of more than 6 months. That doesn't apply. But then there are extraordinary circumstances, this is number 5, that would in all reasonable likelihood result in serious detriment to the child if the petition is denied. And would respectfully submit that paragraphs 5 and 4 directly relate to would directly relate to fitness.
What kind of informal visitation arrangements are going on between these parties since this all started?
My understanding, the great-grandmother would allow the mother to come over any time to see the kid, to see
Only
the
at
child.
her house?
Yes. And two, I think it's important that the family court tailored this order, specifically put in there, if the boyfriend would get counseling for these issues, the court would consider placement back with the mother. That's never happened.
Well, a lot of things didn't happen. Wrong forum, no guardian ad litem. A lot of things didn't happen here.
Sure.
All right, I think we've got it.
Before you do,
sorry.
one question. Was there a request for a guardian ad litem to do an independent investigation in this case?
No, sir.
Okay, thank you.
Okay, briefly, rebuttal.
Yes. Your Honor, I can clear up one thing and I can muddy something else.
2 out of 1 out of 2.
Good news and bad news. Okay.
Syllabus point 6 of Overfield refers to a situation when you are trying to figure out how long the transfer is supposed to be. Is it permanent or is it temporary? And it says that it is presumed to be temporary, and the burden of proof is on the petitioner to prove by clear and convincing evidence that it was intended to be permanent.
But I don't think he's claiming it was anything but temporary.
Right. So that talks. You asked about the burden shifting if we had gotten to that point. So I'm clearing that up, that the syllabus point 6 does not apply to that point. The muddy part is that the prove that you are unfit and all of that is when the parent is trying to get the child back from a permanent transfer, not a temporary transfer. And so I believe the document on its face is clear that it's temporary and not permanent. Everybody was operating under the idea that it was temporary and not permanent, and the court applied the wrong standard by saying this is what you have to prove even in a temporary situation. She said you had to do this, had the burden of proof for a permanent transfer as opposed to a temporary. So she used the wrong standard under the facts of the case. It's
Well, under syllabus point 2, that was the right standard of Overfield, wasn't it? it seems to fly in the face of Troxel.
Well, you're right, I'm sorry.
But did you put on evidence, or did your client have evidence to refute any of the allegations of, or evidence of abuse and neglect?
She testified about it, and there was, and to answer one of your questions, Justice, there was evidence in the FIG about the allegations of abuse. And the problem with it is this: virtually all of the evidence offered by the respondents, it was hearsay. They didn't see anything. They were reporting what other people, including the child, allegedly told them.
Would anybody ever give any evidence that the child was burned, as alleged?
I believe there was evidence that the child had a burn, and my client testified how that happened. And it was the child wasn't burnt. The child, bumped into something or rubbed something. It was an accident. It was not the child, how you put it, the child had a burn. The child was not burnt.
It wasn't like a cigarette burn or something like that.
Right. The child had a wound, but it was not an inflicted injury. And the same thing with the circumstances, with the allegation that he was spanked until he defecated. My client testified of how that happened, and it was not an abusive situation.
And on the allegation of drug use, there was drug testing, wasn't there?
Yes, my client.
They were clean.
Every time.
Any other questions? All right, I think we've got it. Thanks to both of you. This case will be submitted.
We now move to the Rule 19 argument docket, State Ex Rel West Virginia Regional Jail Authority versus the Honorable Kerry Webster and Bobby Dawn Bryant, docket number 19-0595, and this case is before the court under its original jurisdiction.
Good morning. May it please the court. Mark McGee for the West Virginia Regional Jail Authority. We have filed a writ of prohibition based on the denial by the trial court of a motion to dismiss. The motion to dismiss was proper because the plaintiffs below, respondents in this case, had clearly not filed the case timely within the statute of limitations. As such, the claim is time barred, and the motion to dismiss should have been granted. The requirements for issuance of a writ of prohibition in this case are met, as stated in our brief, and essentially there's no factual dispute. In some of these cases, the court finds that factual development is necessary before a motion to dismiss can be granted on statute of limitations grounds. Factual development is not necessary in this case because there's no factual dispute. Respondent's brief in this case acknowledges that the statute of limitations is 2 years as to both the negligence claim against the regional jail and the claim of civil conspiracy. They also confirm that when that statute of limitations would have started to accrue or start to run was the last date that Ms. Bryant was at the regional jail, which was November 16, 2016. As such, under the 2-year statute of limitations, the claim should have been filed against the regional jail as of that date 2 years later.
Well, don't you get saved by the holidays that occurred there in that period?
That's quite possible, but there's no argument made below. That argument has not been made below to try to extend it. And even if that argument was made, the complaint was filed 72 days or possibly 73 days after the statute had run. As such, even if there's a little bit of leeway there, it would not have extended for 72 days. The respondent's brief states that the only dispute before the court is the interpretation of done. Judge Webster's order and the response to our motion to dismiss relies on a minor point trying to justify part step 4 of Dunn's syllabus point 5 with respect to fraudulent concealment. To support that point, Justice Ketchum cited 2 cases from a case from the D.C. Circuit as well as a legal encyclopedia concerning when there's fraudulent concealment, if you hide facts from the plaintiff, then you should get the benefit of extending that statute of limitations via tolling. Surprisingly, the respondents don't rely on syllabus point 4 of Dunn. Instead, they rely on syllabus point 5, which is an other tolling doctrine. I'm not aware of any statute or legal precedent from this court that says the statute of limitations is tolled if you file a medical malpractice action against a co-defendant and allege a co-conspiracy. Under the Dunn analysis, under the syllabus point 5, if you go through point by point, point 1, there's no dispute as to when the statute of limitations would have begun to run. As such, the court could have ruled on that as a matter of law and should have. Point 2, when does the statute of limitations accrue and start to run? That also could be decided as a matter of law. No factual dispute is alleged or contended in this case. It should have started running on November 16, 2016, when Ms. Bryant was transported out of the regional jail for medical care. Point 3 concerns the discovery rule. There's no allegations in the complaint. There's no claim made in any briefing below or in this court that the discovery rule has any application. As such, the court could have moved past that as a matter of law and ruled that there's no discovery rule applied, so we move to step 4. Under step 4, are there any allegations of fraudulent concealment, or is there any basis for equitable tolling of the statute of limitations? There's no allegation of that. In fact, again, the respondent's brief says, we're not worried about that, we're worried about step 5. So if you go into step 5, is there a doctrine of this court or any legal precedent which they can cite to that says there's a doctrine of tolling that says if you file a medical practice action, you get the benefit of the extended time for the medical malpractice action simply because you allege civil conspiracy.
Well, didn't Dunn basically say that because it was told, I mean, in its interpretation in these facts, because it was told as to prime care, that it would be likewise told to as to your client because there was an alleged conspiracy. Isn't that the general rule?
That is the general rule. It says in general, the rule would be if there's a conspiracy alleged, then it would be told as to both. But the factual basis for that, the court's factual basis for that, is that there has to be fraudulent concealment. Absent fraudulent concealment, that rule doesn't apply. The cases from the D.C. Circuit, the rule cited, the legal encyclopedia reference, make clear that you're under Part 4. Under that general rule cited and relied upon by Judge Webster concerns fraudulent concealment. There's no claim of fraudulent concealment.
It seems to suggest that any type of civil conspiracy at all might be clued, just because that was the factual setup in Dunn. Is that not more of a general rule if you look at the whole body of law, when civil conspiracy is alleged?
I don't think that's the way it applies. And it also makes clear in Dunn, in footnote 19, that the general rule is based on, because there's obviously, in a lot of civil conspiracy claims, there's claims of fraudulent concealment. And because of that, often there's tolling involved. There's no allegation of fraudulent concealment. Ms. Bryant knew, as of the time she left the regional jail for medical transport, that she had a claim, and who the claim was against. It was against the medical provider at the regional jail and the jail itself. As of that time, she could have asserted the claim.
Mr. McGee,
yes.
Let me ask just a very basic question. The allegations against the regional jail, are they essentially allegations of the jail being responsible for the medical malpractice of its medical provider? Or are there independent allegations of negligence separate and apart from the allegations of medical negligence?
The allegations are essentially that they should have more closely supervised the actions of prime care. In most of these cases, clearly the medical negligence was by prime care, because the regional jail personnel do not have the specialized medical knowledge. So they've contracted that out to another party.
So it's essentially respondeat superior. You didn't hire the right person to do the job, and these are medical negligence claims, and you're negligent because you didn't hire the right person.
Right, and I would also add that the claim, to the extent it was told against, the claims against PrimeCare, they are told because of the Medical Professional Liability Act. No other reason. They're not told because of the general rule concerning conspiracies. They're told because they get additional time once they file the notice of claim against them. What is the rationale for extending that rule to negligence claims against the regional jail, in essence, the state in this case?
Why wouldn't you extend it to the extent that if the plaintiff is required to give notice to the medical provider and go through the MPLA requirements, you got to give them notice, it's told, they have an opportunity to demand mediation or whatever and try and get the case settled. Why wouldn't you extend that to the person you're seeking to hold responsible on a respondeat superior kind of claim, if all the allegations are essentially vested in that one in the medical malpractice part of the case? Why wouldn't you give both parties, if that's all it is, and you're not alleging independent negligence on the part of the regional jail outside the medical claim? Why wouldn't you give them both? Why would you have to file one and then?
Justice, my understanding of the reason for the tolling provisions is to give the medical provider additional time. It's not to give the plaintiff additional time to assert their claim. If you sit on your rights, you waive your claim. In this case, they had 2 full years to allege this claim against the regional jail. They didn't do so. Instead, they're coming through a back door and trying to allege 72 days after the claim expired and is time barred against the regional jail.
You know, you come on prohibition. It seems like everybody's coming on prohibition. And that's a rather, you know, you have to have more elements than just you contend this is clear as a matter of law. But what about the other elements required for prohibition?
The case law says that on prohibition, the most important is there's a clear error of law. With respect to the other claims, as a general rule, we do not have an adequate remedy. We believe we have a clear legal right, day one, as soon as this case was alleged, that it was time barred. As such, to go through the expense and time involved to litigate that case creates an undue burden on the state in this entity in this case. There's also subsequent, under number 2, there's damage and prejudice to the defendant for having to go through that litigation process when there's a clear rule that the claim is time barred. I would note that this court has twice, in State Rule Ex Rel Monongalia Power, and most recently the last term of this court, on a motion to dismiss, issued a writ of prohibition for inapplicable application of the rule of the statute of limitations by a trial court. I think also based on the allegations by the respondent, this is potentially, if they're correct, an issue of first impression. If they're incorrect, they're making this argument for the first time that this is not an equitable tolling argument. There is an independent basis for tolling based on the Medical Professional Liability Act or some general rule never recognized by this court in Silva's point that if there's alleged a civil conspiracy, simply by that fact, all claims against all defendants alleged in that civil conspiracy are tolled.
Well,
I don't think the court's ever said that.
If this is an issue of first impression, as you say, that is all the more reason it ought to be cooked below before we get it.
Your Honor, I think the court is I think they're simply wrong. I'm simply pointing that out as one of the elements of a writ of prohibition is that it's a matter of first impression. They're making this argument, which frankly surprised me, because I think the argument that made more sense based on the facts was that this was a fraudulent concealment. But because they've made no allegations and have not alleged that below, they're trying to pigeonhole it in the back door under Step 5 of Dunn. There's no rule of law from this court that permits that. As such, a writ of prohibition is proper. The trial court below made a clear error of law that it's manifestly wrong and that the statute of limitations had expired for an extended period of time before this claim was brought. And there's no legal basis for saying that simply because I've alleged a medical malpractice act, I get all the benefit of extending the statute of limitations as to every defendant, simply by filing a one-paragraph general allegation that a civil conspiracy is present between the defendants.
Are there any other questions? All right, let's hear from the other side.
Chief Justice, may it please the court, my name is Amanda Taylor, and I represent the respondent, Bobby Bryant. Respondent respectfully requests that the relief sought by the petitioner in this case be denied for two reasons. First, as Justice Workman points out today, and as she pointed out in her dissent in State Ex Rel Gallagher Bassett recently, the petitioner is here essentially on the appeal of a 12b6 motion dressed up as a writ of prohibition today. Defendant cites clear legal error to this court, but defendant fails to note that what the circuit court did was clearly apply the legal precedent set forth in Dunn v. Rockwell at 225 West Virginia 43. The petitioner wants this court to believe that the Dunn tolling only applies in cases of fraudulent concealment. That is expressly not the case, and a deeper look at Dunn reveals that. Dunn set forth, in fact, 5 steps, 3 of which set forth manners in which the statute could be told. The court made efforts, in fact, to decide and to set out that fraudulent concealment was not the only means. They did that by overruling a decision they had previously made, and they distinguished the discovery rule from fraudulent concealment from other tolling doctrines. And even in Dunn, the court did not decide based on fraudulent concealment. Dunn was before the court on an appeal of a motion for summary judgment. And the question to this court was the statute of limitations told as to lawyer Rockwell and his wife? The court said there was not sufficient evidence for the discovery rule to go to the jury. There was not sufficient evidence for fraudulent concealment to go to the jury. What the Dunn court found was that the Dunns were aware in 2003 of everything they needed to know to bring suit against lawyer Rockwell and his wife. They did not file suit until 2006. But the court said that the statute was told as to lawyer Rockwell because he continued his representation until 2005. The other tolling doctrine applied in Dunn versus Rockwell was continuing representation. And they allowed the claims that were filed in 2006 to go to the jury on that issue because of continuing representation. And significantly, it was not just lawyer Rockwell. The court also said there has been civil conspiracy alleged against his wife to commit professional negligence. And because she is a co-conspirator, the general rule is that if it is told as to one co-conspirator, it is told as to all. It was told as to lawyer Rockwell on professional negligence claims because of continuing representation. The court, because of the civil conspiracy allegation, also told not just the civil conspiracy allegation against Rockwell's wife, but also a multitude, including 5 other claims against her, finding that the causes of action and damages were so intertwined that the interests of the Rockwells were inseparable. And under 12b6, we look at the allegations on the face of the complaint. And what are they? They are that Bobby Bryant was at the regional jail and she was very sick. They are that the regional jail breached its own policies by failing to check on Ms. Bryant, by failing to report to its medical provider that Ms. Bryant did in fact need medical care. There are medical negligence allegations against Prime Care that it failed to give her the care she needed. And there are civil conspiracy allegations that each aided the other in the commission of its respective torts alleged against it. And that's the exact fact pattern in Dunn, that the tolling doctrine, the MPLA here, against the professional tolls the statute as to a civil conspirator to commit that violation. And this case is even more clear-cut than Dunn. I will represent to this court because here there is no dispute that the statute of limitations was properly tolled against Prime Care under the MPLA. Prime Care answered the complaint. I got Prime Care's fact witness disclosure from the circuit court proceeding yesterday. This action is proceeding against Prime Care. There's no dispute that the statute was properly told. And significantly, there is no dispute that plaintiff's complaint stated a claim for civil conspiracy. There has never been, as part of jail authorities' motions to dismiss or appeal before this court, any allegation whatsoever that plaintiff's complaint failed to state a claim for civil conspiracy. So we have an undisputed tolling of the statute of limitations. We have an undisputed claim for civil conspiracy, and that falls squarely within Dunn. And because that falls squarely within Dunn, which does not, as petitioner states, require fraudulent concealment to toll the statute, a writ of prohibition is not proper. All the circuit court did here was take the factually analogous pattern in Dunn and apply it to this case. And that's where we are. And for those reasons, and the reasons set forth in respondent's brief, we respectfully request that this court decline to grant the relief sought by the petitioner in this case.
Any questions? All right. Any brief rebuttal, sir?
I would just say, I'd ask the respondent and the court, what is the rule they're asking the court to enforce? Are they asking the court to adopt this broad general rule stated in the opinion below? If so, what is the basis for that general rule as to all defendants going forward in this court? As to any civil conspiracy, once it's alleged, the statute of limitations, if extended as to any defendant, is extended as to all defendants. The court's never held that before. It shouldn't do so in this case.
All right. Thank you both. This case will be submitted.
The final case for oral argument this morning and for this term is also under Rule 19 of the Rules of Appellate Procedure, Heather M. versus Richard M., docket number 18-1077, an appeal from the Circuit Court of Kanawha County. And I'll remind the court that the respondent did not file a brief or a summary response, and therefore under Rule 19 is not entitled to present oral argument.
All right, so the floor is yours.
Oh, thank you, Judge. May it please the court, I'm Maureen Conley from Legal Aid of West Virginia, and I'm here today on behalf of the mother, Heather M. Heather M. has two daughters, Anna R., who's 11, and Emma R., who is 5. And we had a final hearing in this matter on September 5th, I want to say, of 2018. The parties had appeared once in June of 2018, pro se, and then I appeared on behalf of Heather M. at the September hearing. Our basic contention in this case is that we were not able to present evidence of abuse and domestic violence to the court, which would have triggered application of the limiting factors as per West Virginia Code 48-209A and B. And we assert that under the language of the statute that let me just quote, if either of the parents so requests or upon receipt of credible information thereof, the court shall determine whether a parent who would otherwise be allocated responsibility under a parenting plan has abused, neglected, or abandoned a child, has committed domestic violence, etc. And we assert that both of those, we were prepared to present evidence and testimony on both of those issues, which would have triggered the limiting factors finding. And once that finding is made, it enables the court to apply restrictions to custodial time and decision making. And we felt that both of those were appropriate. We had requested supervision of Mr. R's custodial time, and the court declined to grant that request. He was granted not a lot of time, just 1 day per week, and no overnights. However, it was our concern that it was unsupervised. Things can happen even if it's just 1 day. Children are unprotected, even if it's that limited time. we were also concerned that in the future, he would try or could try to expand his custodial time because this limited time was based on the fact that he was working about an hour away from where the children lived, and he was working 6 days a week, and he didn't have a home. He was living in company housing where he worked. So if that changed, that would give him an entree to expand his custodial time, and we were very concerned about that. The evidence that we planned to present to the judge that day involved telephonic testimony by the child's pediatrician, Dr. Ackland, telephonic testimony by, and by the child I meant Anna R., by Anna R.'s counselor, Paula Mooney, and we also had photographs of bruises of Heather M. and Anna R. to present to the court. The judge declined all of that testimony, and basically, I think her rationale for declining that testimony was the fact that my client had admitted in the temporary hearing and in the final hearing that Mr. R., that she had invited Mr. R. to move back in the home. But she did ask the judge to explain that. The judge basically ruled that that admission on her part precluded further testimony because that admission to the judge meant that she felt that he was a fit and proper parent.
You invited him back in, he can't be that bad a guy.
That's exactly what the judge felt. My client's testimony, though, would have contradicted that finding in that it was her position, she was afraid that the court would grant unsupervised visitation, and she was thinking that if she remained in the home, she could provide that supervision. So even if it made her life miserable, and I think she said that in one of the hearings, she would be able to protect her children. That was the basis for her invitation to him. I think she also had hoped to get counseling for his anger issues, but the judge really did not want to hear that. Refused to hear those explanations. My client also felt, part of her rationale was that he was actually gone from the home a lot. And when he was there, he did not pay much attention to them. So she felt that, in essence, it would be an acceptable way of operating to protect the children. I would note that there are a lot of abused women who are concerned about whether the system is going to work for them or not. And at the time of separation, there is a lot of danger to an abused woman because that is the point where their spouse may become even more violent than usual when they're losing control over a situation. So I think when an abused woman attempts to plan to leave a dangerous situation, she has to think through what the possible outcomes are going to be. And I think for her, it was unacceptable that he would be alone with these children without someone there to protect them.
Well, and it's your contention here that the record below reflects that the judge refused to permit any evidence to be presented on the alleged abuse.
That's correct, Judge, and it's not in one place, it's in several places. She simply said that she was not going to allow the doctor's testimony because she's a pediatrician and she's probably only spent 5 minutes with the child, and that she did not think that the pediatrician was an appropriate person. AR 156 appendix record, 156, she says she didn't think a pediatrician could weigh in on that. And then when offered the counselor's testimony, she said, well, this child has had anxiety for over a year. I'm not going to lay that on Mr. R. Basically, she was saying that he's been seeing the child and he can't be blamed for all of this anxiety.
So did she refuse to hear the counselor's testimony?
Yes. And it's our contention, Judge, also, and I think I cited this in my brief, that there is now a whole body of research on the issue of ACEs, adverse childhood experiences. And I cited a 1998 article about that, but the CDC has a very nice section on ACEs, and actually the states, including West Virginia, contribute data to the CDC on this issue. But what this whole body of research is now showing is that these adverse childhood experiences, these traumatic experiences, continue to affect children as they grow into adulthood, not only with mental health issues, but also with physical health issues. And there are now a number of psychologists who interview children about these traumatic incidents and give them what they call an ACEs score and so on to determine how deeply they have been traumatized. But I'm just saying this because the judge felt that she could exempt Mr. R from any blame because time had passed and the child had had this anxiety for a while. I think what we are saying is this child's anxiety is still worthy of exploration. In fact, it's mandated that it be explored under the statute. The child had recently talked to the pediatrician, and we did not get to present this evidence at the hearing, but we did submit it by proffer. It is also in the appendix record, and I don't know the exact page, but I believe it's pages 82. The doctor's visit is page 84, and the child's statements are quite compelling. I believe that they would clearly meet the threshold of credible evidence. And the judge made several conclusory statements showing that she was clearly ruling before she heard evidence. One statement, when did he supposedly start treating the girls bad? That was on page 117. And the judge also indicated that, she concluded that she was supervised, custodial time was not required. She told my client that she just wanted to prevent Mr. R from seeing his children. My client said no. She wasn't trying to prevent that. She was simply trying to get supervision, and the judge basically refused to accept that position, even though in her proposed parenting plan, which she filed before the final hearing, the amended parenting plan, she actually contained the same visitation allotted to Mr. R by the judge in the temporary hearing, these daytime visits on Saturdays. She just asked that it be supervised. So she continually tried to tell the judge that she wasn't seeking to deprive him of custodial time. It was simply protection that she was looking for, and she was really unable to present that. We were unable to present that.
And as a practical matter, fast forward the case has now been referred to the circuit court, is that right?
It was. There was, Mr. R. had voluntarily chosen not to exercise his custodial time. And actually, it's been over a year now that he has not gotten his regular Saturday visits. But that he did see the children at Christmas time.
Yeah, this is by his own wishes? He
saw them
choice?
for a couple hours to give them gifts at Christmas time. And other than that, he has not had his visitation. But this past summer, he had indicated to my client that he was going to start getting the children for his visits. And when my client informed the children that they would be seeing their dad, her older daughter really was very upset. And based on her daughter's statements to her, she filed a petition for a protective order, and Judge Van Meter conducted a hearing on that in August. And Mr. R. agreed to the entry of a no findings protective order. At the same time, she made an overlap or administrative order to the circuit court, referring the case up there, and Judge Tabbitt issued an order, I believe on September 5th, dismissing the overlap case, but saying that they acknowledged that there were issues and that the family court was addressing those issues. One of our concerns, and I would just note that in addition to the requirement of the statute, there are of course due process requirements, and I think the old case of Simpson versus Stanton from 1937 articulates it very well when it says that the court should basically hear before it condemns, it should proceed upon inquiry, it should render judgment after trial. And I think when you read through these transcripts, or better yet, when you listen to the CD-ROMs of the hearings, which I believe are in the record, I think they're very compelling and show that, in fact, this was not the case here, that she did not have an open mind, that the judge did not have an open mind to the evidence simply because of my client's admission, which I mentioned earlier.
Has the father exercised visitation since Judge Tabbitt entered the order in September?
No, because the protective order is still in effect. I think it's in effect until, I'm not sure if it's January or February of 2020. However, we will...
what does it provide with regard to the children, the protective order?
It suspended his visitation, yes, I'm sorry.
When was that entered, that protective order?
I believe it was August 5th.
And prior to that, he had how much visitation had he exercised?
He had not exercised his regular visitation since October of 2018, except for the Christmas visit.
Okay.
The judge, I just also wanted to just mention the precedents here, the State versus Ruckman, Henry versus Johnson, and Henry versus Johnson recites several cases, including Mary D. versus Watt, Mary M.P., all regarding supervised visitation. And I think it's interesting to go back and look at the language of Henry versus Johnson because it kind of predates this whole ACES development, that domestic violence can cause deep and lasting problems. And that is the case here. These problems are deep, and they appear to be lasting, and they deserve to be heard in the court. Now, if I may just move briefly to the tax issue, we also were challenging the fact that Heather M. was not given the right to get the child tax credit for both children, just one. And the judge's decision on that was because he was paying a hefty sum in child support, $1,080. She, again, did not take evidence about how that would affect either party. She simply made her decision and said that she had the discretion to give him the credit for one child in future years. She gave him the credit for both children in 2018. And actually, it's our contention that the statute doesn't really give her discretion unless he were awarded extended shared parenting, which he was not. But also in this case, it does not appear that the statutory requirement that the funds available to that the best interests of the children would be served by giving him the credit. As you probably know, that the child tax credit was changed in 2017, and now they do it as a credit, not an exemption, a deduction, and it's $2,000 per child if you have a minimum of $2,500 a year income. So we are asking that the court grant her the right to claim both children as provided by statute. And on the other issues, I believe we do need to have a remand because the evidence has not been presented yet. But we ask in this case that it be remanded to a different judge simply because this judge apparently had made up her mind. She actually promised the parties that they could come back at the temporary hearing. She said, well, you can come back and present your evidence at a final hearing. But then at the final hearing, she did not permit that.
I think we understand. Does anyone have any questions? Okay, thank you very much.
Thank you very much.
This case will be submitted.